floor, page.
Yes, Professor George.
My lords, my lady, if it please the court, I appear on behalf of the appellant in this matter together with Mr. Barun and Malemu. My lords, my lady, you'll be aware that our skeleton argument was also settled by Miss Weston of King's Counsel.
Yes, we're sorry she can't be here, but quite understand.
Thank you, my lord. She sends her apologies for her absence. My learned friend Mr. Turner of King's Counsel, together with Miss Wiseman, appear on behalf of the first respondent. And my learned friend Miss Basley of King's Counsel, together with Mr. Eaton and, beg your pardon, Mr. Landman, who was with Mr. Turner,
yes,
appear on behalf of the second respondent.
Yes, and you've put Mr. Gratian at the back.
Mr. Gratian's put himself at the back, my
Yes.
lord. I think on the basis that the Guardian has not taken a position in this hearing, Mr. Gratian, together with the Guardian who sits next to him, Mr. Lowe, I think are here primarily to ensure that they are prepared for the welfare hearing that is to
Yes.
follow.
Well, can we approach it in this way, that provided Mr. Gratian is from where he's sitting able to hear what we all say, that when the time comes that we've heard other submissions, I'll invite him to make any submissions that he wants to make in relation to any legal matter, even if he doesn't take a position in relation to the appeal itself. It's obviously an important matter for his client, and we're not going to stand on ceremony. Clearly, if he makes any points that fairly require some response, others will have that opportunity.
Thank you, my lord.
Ms. Gratian, will that do?
Thank
you. Yes.
Lord, may I just mention my client is at the back of the court as well.
Thank you. Thank you very much. Good, and we know that others concerned, I hope, will be able to follow this on the live stream.
My lord, yes, thank you. My lord, you've got at your direction a additional mini bundle of
Thank you.
documents. The hard copies are on your lordship's and your ladyship's desk. I
Well,
hope
we've obviously had a good opportunity to read everything. I'll take your view on this, which is that although this has been listed under an initial, as is common in this court, it's not the same case name as is used by the judge. I think probably by the time we come to give a judgment, we'll follow the judge's scheme and the judge's title for the case, if that seems sensible.
my lord, yes, and of course.
You can also tell us, just for practical purposes, because of course the substance of it is not our business, what the arrangements are for the hearing before Mrs Justice Knowles today and tomorrow.
My lord, yes, the judge has I believe, short hearing at 2 o'clock on another matter and is then scheduled to hear this case. I understand the position in that hearing, for I am not actually instructed to appear in that stage of the proceedings, that what is then to happen will depend to some extent on whether this court has given a decision as to its outcome, obviously not the judgment
Yes.
today. But I think it is set up for a substantive hearing and that all the evidence that is expected for that hearing is...
So the case is ready to go before Her Ladyship, subject to the decision of this court. And of course, as I foreshadowed, if we're in a position to tell you what our decision is, I say if, then we'll do that. Anyhow, that's helpful. We know we know that that's going to be going on one way or the other.
Yes, thank you.
All right.
Well,
Yes.
my lord, obviously the court is very familiar with the matter, having read the papers, but I'll just set, if I may, some brief context to the legal issue that we're concerned with today, and which is to say we're looking at the fundamental question of who are X's parents. And of course I'm using the same nomenclature as the judge below has used throughout. It's a case where X has been brought into the world by a then married couple who took numerous steps over a significant period of time to have a child together. X has been brought up knowing about F and who he is, and that he is the biological father, but not equally knowing or thinking that he was one of her parents in the meaningful sense of that term that we're concerned with, and that the parents are P and Q. There are a number of legal consequences, and my learning from Mr. Turner has set some of them out in his note as to what it matters to be a legal parent, and I don't dispute any of that. But I would like to just step back from those legal consequences and think that there are also quite significant social consequences, and you might say non-legal consequences to who the question of the parents are. It determines the kinship relationships. Who are the grandparents, the aunts and uncles, cousins of this child? It determines, to a very real extent, how she identifies herself, who she is as a person. Now, of course, we recognise that there are cases, the court will be well familiar with them, that everybody involved may think that one person is the child's parent, and it may turn out that they are not, and that is not an infrequent or uncommon event. But the way that turns out is that on investigation, some fact is proved that shows that the mistake existed that led to that initial view. And in this case, one of the difficulties that the court below faces and that this court faces is there is no proven fact that establishes that there is any underlying mistake as to how X's parents were conceived to be at the time of her birth and for the several years thereafter. What this case has is a factual unknown, and I will come back to that in more detail. And so we see a lot, including in the judgment below, about the importance in these types of cases of establishing accurate knowledge about a person's parentage, in Mrs Justice Knowles' words. And in the numerical majority of cases, what accurate knowledge about your parentage means is a proper understanding of your genetic origins. And that is readily established in most cases by way of DNA evidence. But in the minority of cases where donor gametes have been used to lead to the conception of a child, we are specifically not concerned with genetics as the primary question of who your parents are, or accurate knowledge of the person's parentage. Genetics is disapplied by the HFEA scheme as being the appropriate test in those cases.
Just thinking about what you're saying, you're right now about the fact that scientific testing can now, in the great majority of cases, achieve accuracy. But I can remember when that wasn't the case, and when scientific testing just gave you a more or less good idea about that. So do we not have to contemplate a submission about accuracy? Remembering that accuracy is quite a new concept in this area.
My lord, yes. And of course, going back to those older cases, what one tended to look at alongside the scientific evidence was the wider context, and things will be placed in the wider evidential context. And we say in this case that was in a significant part of the factual matrix of the case that didn't get factored in appropriately to the decision of Mrs Justice Knowles. And so I'll come, if I may, in due course to it, but the most significant piece of that factual matrix is the birth certificate and what was recorded on that document and what the status of that document is. And the judge below has specifically said that she doesn't wish to consider that in her judgment. He doesn't give weight to it, and we say she was respectfully wrong not to give any weight to it. We say it provided a significant starting point indeed as to the factual matrix against which the other evidence that she had was to be assessed.
But that rather depends, doesn't it, on the accuracy of the information given?
My lady, absolutely right. And of course, if there were evidence that disproved the substantive content of what was on the birth certificate, we have no difficulty in saying it would fall away. It isn't a conclusive piece of evidence, and we certainly don't suggest that it would be. But as I'll come...
But I'm a little puzzled as to the more general submission you made as to the wider context, as you put it. I mean, never mind the specifics of the birth certificate. But in this court, we're faced in a situation where the facts, to the extent that they are ascertainable, have all been found.
Yes.
And therefore, it's purely a question of the correct legal analysis, is it not?
My lord, yes, I perfectly accept that. And the question of where do that wider context fit in to your lordship's question, I think, is this, which is that in deciding, effectively the court has to make a decision which of the two possible legal frameworks is in application in this case. Is it the common law position where genetics is the answer? Is it the HFEA position where genetics is disapplied?
Well, indeed so. I think you framed the question entirely accurately there. But isn't that confirmatory of the question that I was putting to you?
And my lord, it comes to this then. How is the court to make the decision which of those two is in application when the factual findings that the judge has made, quite rightly, simply don't answer the question on the details of the mode of conception? And that is where we say the starting point of what was in place before the question was asked is the relevant starting point. And that's where the birth certificate is a starting point. Going back to my lady's question, it's not the end point, but it's a starting point. What information was put on that document? What did the parties do more generally in their attempts to conceive? Obviously, that doesn't tell us. It doesn't tell us what happened at the moment of conception because we can't know. But we're trying to place that into the context of what we do know. And so, to some extent, it gives a context. Going back to my Lord Peter Jackson's question, that we have that wider evidential framework that can assist us to a limited extent. The case here turns on the unknown fact, and so the question is simply which party had the burden of trying to prove the unprovable. And that is the question goes back to the starting point of which of the two legal tests is the starting point in this case.
It's not really which has the burden of proving the unprovable. I mean, as it turns out in this case, the fact-finding could only go so far. It's really which party bears the consequences of the fact not being able to be conclusively established.
My lord puts it better than I did. And
I think we're talking about the same thing.
It's the same point, my lord, and I think your lordship has put it better than I did. But in another case, this isn't an unprovable fact.
No, I mean this is, see, as it seems to me, on any view, an extremely unusual case. But I'm sure that all the parties have written on the basis that this sort of thing happens.
Yeah.
When people wish to conceive, they will try many different ways of conceiving, and that's quite understandable. But even in those cases where this does happen, and there are a few reported examples, the fact that one actually arrives at a position where it's impossible to tell is going to be only a subset of that subset.
My lord, yes, and
I mean, as it happens, unfortunately for everybody involved in this case, it hasn't so far cropped up. This is the first time that it has cropped up. But we're obviously faced with a situation where there's, whatever the correct analysis is, can't be made to fit into the facts of it can't be changed one way or the other because of the facts of a highly unusual case.
My lord, no. The
principle's
correct
the
approach
principle.
is the correct approach, whether it has fortunate or unfortunate consequences for these particular individuals. And I don't think we suggest otherwise.
So we were interrupting you, but I'm anxious to fully understand in what way what you describe as the context can actually bear upon the facts, because I mean, how can that change the facts?
Well, it doesn't obviously change the facts, but the starting point of our factual findings from Mrs Justice Knowles is we don't know.
Yes.
We can't know.
Yeah.
And so the question then is, where does that leave the analysis? And what we're saying about that wider context is that it feeds into the starting point of, are we asking, as the respondents to the case would have it, and as Mrs Justice Knowles had it, has the appellant in this case shown that the common law is out and the HFEA scheme is in which case it is for her to show something, whatever it is. And we say that wider evidential framework, in particular what's in the birth certificate, is the most compelling part of that, is what starts us off under the HFEA and says that the question of whether we are coming, the question is whether we're coming out of the HFEA, not whether we are going into the HFEA. We say it is engaged until it is shown that it is not.
I ask this question from a point of view of complete ignorance. The impression I've got from what I've seen so far is that there's not a word in the HEFEA about birth certificates. Is that correct?
That's correct.
So if that's right, what's the foundation for your submission that the birth certificate becomes relevant to the question of starting point?
Perhaps we turn to the statutory language, my lord.
Right. That's always a good starting point, yep.
So I'll just jump along slightly. If we can start at authorities 413. The authorities 413 at the top, we've got section 34, which is often referred to as the gateway. And this sets out when the HFEA scheme applies in terms of determining parentage. And so we see in subsection 1 that the relevant provisions apply in the case of a child who is being or has been carried by a woman as a result of placing in her of an embryo or of sperm and eggs or of artificial insemination. And your lordship is obviously right, there's no mention here of birth certificates. The relevance of the birth certificate is a slightly different one, which is that it is an immediate post-birth document which has an official status, and that is underpinned in particular by the fact that providing or willfully providing incorrect information on that document is perjury. I'd just like to be clear, we're not making any complaint about anybody's conduct in this case, and even if we were, there's a 3-year time bar on.
But in any case, in this situation, for 5 years, everybody believed that your client was the legal parent.
My lord, yes. And that,
I mean, even P believed that.
yes.
Um,
And so that document reflected everybody's belief, not only about their sort of lived experience of it, but also about what was the proper legal status of it. Now, they may have been wrong. That's obviously a possibility. There are many birth certificates that are wrong. It comes back to my lady's question earlier. So it's not that the birth certificate provides us with an answer in that sense. But there is, we say, at the starting point that it should be presumed that that document is accurate because of the pain of perjury that comes with it being incorrectly completed. And it is for the person who wants to say otherwise to provide the evidence that it is wrong. And that's where it comes back to my lady's question. Who has to show that the birth certificate is wrong? The person who wishes to assert that.
But isn't your difficulty that there are no findings of fact in this case which are unappealed? One of which is that F is the biological father.
Well, my lady, that was never a matter in dispute because he was the biological father either way, because he was either the sperm donor or he was the man who conceived following intercourse. So the question of the biology of it doesn't advance the answer to the question, because the answer to the question isn't what are the biological progenitors of the child. The question is which legal framework applies to tell us whether biology is the question or something else is the question, the HFEA scheme. So that finding, we say, was not ever in dispute. The finding of whether there was intercourse was obviously not known to my client, so was in dispute in the sense of it was an unknown piece of information that was tested in evidence, and the judge made her findings, and we don't seek to challenge them.
So coming back to the statutory language, you referred to section 34 as the gateway, and I can understand why it's called that. Would you accept, well, you obviously don't accept the respondent's argument that in order to pass through the gateway, it must be shown that the child is, quotes, a result of the placing in the woman of an embryo or of sperm and eggs or her artificial insemination. But what I'm struggling to understand is why you don't accept that.
Well, Lord, I don't think it is that we don't accept that it doesn't have to be shown in a sense. What we don't accept is that in a case where 5 years have gone by and they've all behaved in various ways, formal and informal, on the assumption that it does apply, that on then the raising of doubt, which is the word Mrs Justice Knowles uses a number of times in her judgment about whether it is engaged or not, it isn't for the person raising the doubt to show that it doesn't apply, rather than shifting over to the respondent to that application, then being placed in the position of having to prove
can we move away?
it
I
does.
understand why you focus on raising the doubt, but that's not really what she decided. What she decided was that it was equally likely that it was by one means or another. I mean, we can't just pick phrases out of the judgment. The finding of fact is that it's impossible to know. It's not just a doubt.
The finding of fact, my lord, I completely accept is that it's
Yes.
impossible to know. But the analysis of when does the HFEA apply and when is it disapplied, that, in my submission, does turn on the judge's assessment as to the doubt element. And we can go to that point in detail now, if that's
No,
helpful.
take your own course. But we were slightly getting away from the point about the birth certificate. I'm interested in your submission, which I noted as that the birth certificate should be presumed to be accurate.
Yes.
That's not, as I understand it, the state of the law. The state of the law is that a birth certificate is prima facie apparent
Yeah.
evidence of parentage, but it can be displaced by proof of facts.
Yeah.
So it's evidence. There's no presumption, as I understand it, in favour of a birth certificate. The birth certificate is an extremely important document, evidencing people's understanding of who people's parents are. But that's different from saying that there is a presumption at work. And if you want to establish that there is a presumption, I need a bit of help.
I think, my lord, that I don't think I'm making a different point from your lordship. I think I'm making it less well. But the birth certificate does it does a number of different things, but for our purposes it does two different things. One is that it does its own function as a document recording birth,
Yeah.
and with the relevant consequences of that, nationality, passport entitlement, and so on. It does all of those things, and for those purposes, that is what I'm saying, that unless challenged, the document is what it is.
It's incredibly important for all purposes in life, and most people's birth certificates stay with them throughout their lives and are as good as proof of parentage. But that's not actually what they are.
My lord, no.
They're evidence of what people understand the situation to be and what the state has accepted the state of affairs to be.
Yes.
So, on examination, you're not arguing that there is a legal presumption
No.
in favour of the birth certificate.
My lord, no, but that it has this status which is beyond, for example, the parties in this case also wrote an informal agreement between themselves, and we don't suggest that has...
In the hierarchy of documents, it'd be hard to think of a document which is higher up the hierarchy of documents than a birth certificate. It is the top document.
Yes.
Your will and your marriage certificate and things like that are up there as well, no doubt, but the birth certificate is the top document. But it's nevertheless a document that stands for what it stands for.
I don't take issue with any of those points. But in a case where the key factual issue of the method or mechanism of conception is unknown and will never be known. The question is whether what is on that document has in any way actually been challenged in a meaningful sense. It's challenged in the sense that there's the possibility that it's not correct.
So the birth certificate is recording the Registrar General's understanding of the legal parentage of the child, is it not?
It is based on what the parties have
told. Yeah. So in that sense, coming on to what you were next addressing us on, which was the 5 years, you know, the accumulation of actions, commitments, expectations that grew up on everybody's part during those 3 years and the 5 years.
Yeah.
How can they make any difference?
My Lord, it's only this, that in terms of understanding this starting point of who has to show what, there is a common understanding in this case that this was a family whose child's parentage was determined under the HFEA scheme.
But that's to beg the question. The question is whether it's a common understanding in one sense, yes, but it might have been a common misunderstanding.
Indeed, but it comes back to the point that we make, that it's the person who wishes to challenge that starting point, that understood position, who is the one who has to demonstrate.
So you say, essentially putting it in a nutshell, that the starting point is the understood position.
My Lord, yes. And I think we can see there might be a slightly different case if one went back in time and all of these events had unravelled during the course of the pregnancy, say. And so there hadn't been that starting point, that understanding. And in that case, there wouldn't be this wider contextual starting point.
There wouldn't have been.
In that case.
There wouldn't have been.
No.
So does that lead to a different conclusion?
Well, it leads to, in a sense, the court being in an even more difficult position because it doesn't even have that. But
why, I mean, to test your thesis, why should it make any difference? I mean, it seems very implausible that had this all broken down during the pregnancy and there then been an immediate dispute about who was the parent, that the answer could be different because it happened, you know, in the first 6 months rather than 6 years later.
My Lord, I think we agree that it can't be different, but the helpful point that we have in our case that doesn't exist on my hypothetical alternative is that we do have that context.
But my point is the different one, which is I can't understand how the context can help you if the outcome can't be different. Well, your counterfactual situation seems rather to expose the difficulty with saying that context has got anything to do with this.
There has to be a starting point of some sort in this case, because somebody needs to be this child's parents. There's no question that there is no answer. So there has to be an answer. And so the question is this, excuse me, is which starting point do we have in a case where a married same-sex couple engage over a number of years in attempts to conceive artificially, but also, as it turns out, in the relevant window, birth mother engages in sexual intercourse with the person who is also the donor, and therefore we can't genetically answer the question. And we say that fact of that starting point that we are in, a same-sex marriage relationship where they are attempting to do all the things under the HFEA that would engage that scheme, is what engages that scheme. In our case, we also have the fact that that has been affirmed by their behaviour in the post-birth period, and in particular what they told the registrar at the registry office. So it's in a sense evidencing what comes before.
But one would expect, if, let's say, you've described it conveniently as context, all the human activity that we perfectly understand has gone on in X's life, fully involving your client for much of it. One would expect that if all that evidence was of any use in deciding this dry legal question, that one would find that if one went back far enough and one changed the facts enough, that it would lead to a different outcome. That it would lead to an outcome that would say, well, actually, because of the context, somebody else is the father. But do you concede that?
I don't think I do concede that, my lord.
No. So in that case, if it doesn't matter, it doesn't matter.
Well, I think what I'm trying to say, and I'll see if I can say it better, is that what has happened in that post-period, the context period that I'm talking about, is what demonstrates what had happened in the pre-period. And so it's about showing why the HFEA is our starting point in this case, in a way that it might not.
It would have been, I mean, let's suppose you take the case that you set up, which was that the female parents had fallen out during the pregnancy, as indeed has sometimes happened, and they were straight into court after the birth, and within the child's first year, during which time somebody in your client's position had not had much to do with the child, the decision about who is the parent had to be made on the same facts surrounding the conception. You're not saying that would lead to any different conclusion.
No.
Right, so I then come back to ask you, what possible difference can it matter that the matter wasn't decided until 5 years later? And that it depends upon who did what during that period.
My lord, I don't think that is. I've obviously not put my point well, so I'll try it differently. I'm not trying to say that what they have done post-birth changes the events. I'm trying to say that in terms of understanding why the HFEA is the scheme, that comes back to the conception. Nothing that they did after conception actually mattered. But since we don't know what happened at conception, we are looking, I say, at that context around the conception. So it's what were they doing in the run-up to it? The fact that they had engaged multiple times in attempts at...
But all this would have a lot to do with the findings of fact. It might very well have persuaded the judge that there was some reason to favour one conception possibility over the other. But once that's all past now. And once it's past, I won't keep interrupting you about this, but I can't at the moment understand how what happened before or after that can make any difference, because we know that it can't be known.
In a sense, my lord, the judge has to make a decision whether she thinks it's one or the other, because that's how she knows whether...
As you very well put it earlier on, between which is the framework that is engaged.
And the judge below has obviously made the decision that the framework that's engaged is the common law framework, because she has said the HFEA scheme is not engaged. But we say she doesn't have an evidential basis to say that it's not engaged. She doesn't have an evidential basis that tells her either way which it is. But that then begs the more complicated question, which I'm afraid this court is faced with, of how does one decide?
Well, exactly.
Which
and that takes us back to the statutory scheme. Now, you accepted the suggestion that there was nothing about birth certificates in the relevant provisions of the HFEA. But I've noticed, while you've been talking, that we do have reference in provisions that are not applicable in the circumstances of this case. I just want to ask a quick question about that.
Yeah.
So I've noticed that we have reference in section 39 to subsection 3 and also section 40, subsection 4 to entering particulars of a child's father in a relevant register of births in the circumstances to which those provisions relate.
Yeah.
So that leads me to two questions which I'll ask together because they relate to each other. One, this shows that, as one would expect, Parliament wasn't ignorant about birth certificates when it legislated in 2008. On the contrary, one can see from the face of the statute that this scheme in the 2008 Act was designed to dovetail with the pre-existing statutory schemes for registration of births. Secondly, what this tends to suggest is that what happens to the birth certificate is a consequence of the statutory scheme where it's applicable, rather than the statutory scheme being a consequence of the birth certificate. Would you accept those two propositions?
My Lord, the first, Section 39 and its equivalent for same-sex partners later in the Act is performing a very specific function, and that is to do with allowing the would-be father or would-be second parent who has deceased prior to the child's birth to be recognised for limited purposes, and the limited purpose is to be named on the birth certificate. But the provisions are controlling what the consequences of that are. But yes, obviously it is there, and I don't suggest that Parliament wouldn't have thought about that interaction. And yes, to your second question, my Lord, yes, the birth certificate flows from the statutory scheme and not vice versa. We can also see elsewhere, give me a moment, I'll just locate the reference, that there's amendment also to the to various other statutory schemes that flow from the HFEA being introduced. So the 1953 Death Registration Act has amendment that flow from the 2008 Act. And so, my Lord, you're obviously quite correct that these things have been, the dots have been joined up in parliamentary thinking. So I think inevitably in all cases, the birth certificate is a consequence of the legal test that applies to determine your parentage. But in a sense, it still begs our more fundamental question of which test applies on the facts of a case where one doesn't know, unusually, the mechanism of conception. Can I take us to section 42 of the HFEA, which is at authority 418, bottom of the page. This is the provision which has an equivalent for heterosexual couples earlier in the Act, that applies, as in our case, where the parties are married or in a civil partnership.
Which is the, I beg your pardon, which is the equivalent section?
35, my Lord.
Yes.
The significant thing to pull out of this section for our purposes is, at this stage at least, that as distinct from the following sections dealing with unmarried couples, Parliament has given married couples a greater leeway as to how they conceive their children. And it does that in two ways, one of which is not relevant, one of which is. The not relevant way is that they can do it anywhere in the world, and they're not limited to doing it in the UK for the purposes of the Act. And the second, which is relevant, is that they are not limited to going to a clinic. They are free to approach their conception in a DIY manner, if I can.
When you say married, you mean also civil partner?
Married or civil partners, yes. The Act treats them exactly identically. So since this couple is married or was married, I use that term.
Right. So if you're an unmarried, unpartnered couple, you have to go through a clinic.
You do, yes. And that's a significant point of context here, that Parliament has specifically allowed for married and civil partnered couples to do what this couple did and still be within the HFEA. Parliament has created a situation where the evidential frame of what will be known will often be far less clear than in the case of a clinic. Not that there are cases involving clinics that don't involve their own difficulties, but the starting point with the clinic is that one will have a clear set of information as to what has happened with what gametes to which people.
Apart from clinic error cases, the issue of parentage is going to be much more certain following clinic treatment.
Yes. But the policy that Parliament has enacted here specifically allows for this more wide-ranging set of circumstances for couples who are married or in civil partnerships. So those who have formalised their relationships get the benefit of a far wider range of behaviours which still fall within the Act. And that comes back, I think, to understanding what has to be met to get through the gateway, because there's always the possibility, when one hasn't got that evidential basis of a clinic, that there will be unknowns and uncertainties that don't exist in the clinic context. And we're conscious that there's the risk that wider availability granted by Parliament to married and civil partnered couples does risk, to some extent, coming under challenge if the judge's approach below is correct, because it creates the possibility that behaviours that Parliament has specifically endorsed are far more open to challenge, and that, particularly in the context of Section 42, when one's talking about the same-sex parents, that there are consequences to that do not apply to other couples. So we're just conscious of that as part of the context of this. And in terms of understanding the policy, the starting point has to be, because of the nature of those institutions, that marriage and civil partnership are seen by Parliament to be presumptively monogamous relationships. And so while, of course, in the context of a same-sex female couple, a man's sperm will be involved in conceiving a child, the fact of their marriage is taken to be a starting point, that they will be in a committed monogamous relationship. And we know on the facts that's not what actually happened here. But that's the policy starting point, and why marriage and civil partnership are treated differently from unmarried couples. Can I continue my statutory journey by turning to the provisions in relation to declarations under the Family Law Act, and at page 438 of the Authorities Bundle, section 58 of the Act.
It may be this isn't a sensible question, but how does one approach the two statutes? Does one enter the discussion as we've been doing through the HFEA, or does one enter the discussion on the issue that we face through the 1986 Act?
My Lord, I asked myself the same question in thinking about my submissions, and I've landed on HFEA and then the 1986, but I'm not sure that that's. I think they come as part of a holistic analysis, if I can adopt a phrase from another part of the forest. So at 438, section 58, this is the general provisions in relation to declarations of various kinds.
Well, can I just ask a quick technical question prompted by that observation? Obviously, the 1986 Act predates the 2008 Act, and therefore one's instinctive reaction is to think you've got to be careful about construing the earlier by reference to the later. But on the other hand, I see it's been amended post-2008.
Yes.
But is there any specific amendment that was consequential on the 2008 Act?
My Lord, I don't know, but I don't think so, because I don't think that the provisions, certainly the ones we're concerned with in relation to these declarations, I don't think are actually affected by the Act, because one of the things that's clear from some of the case law not in the bundle is that one can get a declaration of parentage that the person under the 2008 Act is your parent. And so it's simply a declaration, the decision of Mr Justice MacDonald, I'm afraid the name currently escapes me, where it's specifically in question is who is the parent under the 2008 Act, and the declaration is made under Section 55A.
But the 1986 Act, which we're looking at the moment, is not just to do with parents of and children of assisted reproduction. It's
No.
just
No.
parentage generally.
Anybody. Yes, anybody.
And also when we're looking at the 2008 Act, 2008 Act is in a sense a cousin of the 1990 Act, which remains in existence for large numbers of purposes.
Yes.
The 2008 Act is an extension of that Act, but not a replacement for it.
I think it replaced some provisions of it.
Some provisions of it, but
but
the two, I mean, depending upon what sort of family situation you're dealing with, you may find yourself in 1990 or 2008. We happen to find ourselves within 2008.
My lord, yes, I think the 1990 Act regulates more to do with holding of gametes and storage clinics and so on. But yes, I think one can find oneself in both or either.
And the assisted reproduction legislation goes back, in fact, to 1987, to the Family
Law Reform Act, I think.
Yes.
Yes. Can I take us to section 58?
We have it.
Thank you. So subsection 1 is the general provision, where on an application to a court for a declaration under this part, the truth of the proposition to be declared is proved to the satisfaction of the court shall make that declaration unless it would be manifestly contrary to public policy. We're not concerned with the final part, although Mrs Justice Knowles was, but that issue was dealt with by her and is not under challenge. The purpose of my taking you to it now is to highlight the words, the truth of the proposition to be declared. That is what needs to be proven to the satisfaction of the court under this provision. And just before we leave section 58 and go to 55A, just to highlight also subsection 3, that section 58 isn't granting the court a wide-ranging inquisitorial power to make appropriate declarations as it sees fit on the evidence. It is granting the court specifically the power to make or refuse the application that has been made, the declaration of the application that's been made. And so subsection 3 says the court shall not have any power to make any declaration for which an application has not been made. So I just highlight that. And if we could turn them back 3 pages to 435.
Well, just before we go to that, can I just ask you a question about section 58, subsection 1, because this is really an important plank in your argument, and I understand why. You emphasise, and again I understand why, the words, the truth, the proposition to be declared. But presumably you would accept that that can't mean whether common law or the HEFA applies. It must be the truth of the factual proposition.
Well, I think, my lord, this is where I'll take us to section 55A, because that tells us what is the declaration that the court is actually making. And so that turns to what I think will be the answer to your lordship's question.
The question I just asked is wrong, isn't it? Because it's not the factual proposition, it's who is the legal parent, which is not a factual proposition, it's really a legal proposition.
It's a legal proposition. Yeah. And so, precisely so, and if we turn back those 3 pages to 55A on 435, subsection 1 is exactly your lordship's point, that the declaration, any person may apply to the High Court or the Family Court for a declaration as to whether or not a person named in the application is or was the parent of another person so named. So this is the proposition that is being declared on the fact of our case that Q is not the parent and that F is the parent. And
well, forgive me for interrupting. I mean, the declaration was in 2 parts. Speaking for myself, I think that is of some importance, because the first part, the first declaration being sought, was that a man called F is the legal parent of X.
yes,
I'm sure I'm being pedantic, but I do think that is of some importance. We don't jump to the second, we deal with the first.
in terms of the way that Mrs Justice Knowles' order was structured, my lady.
Well, no, not necessarily just that. The approach of the court. That is the first declaration sought.
Well, my lady, we say that these 2 declarations must go hand in hand.
Well, I'm not disagreeing with that as a proposition, but simply as the way the court is looking at it, the first declaration sought is F is the legal parent of X.
I don't think I can take issue with the fact that that is what was sought, my lady, but I don't think I accept the proposition that that the way around in which those two propositions were sought or were made.
It wouldn't make any difference if number one was that Q is not the legal parent of X, and number two, that F is the legal parent of X.
One could seek either declaration. I don't think one can seek the declaration that, in this case, one can't seek the declaration that F is without also seeking that Q is not. But in another case, one could seek a declaration that a person was not, but not be seeking a declaration that a particular other person was. A case where a conception arose, the husband, say, thought he was the father. A declaration can be made based on the genetics without knowing who's...
But he's not the father, but we're not making a finding as who is.
My lord, yes.
Yeah.
So they don't necessarily go hand in hand on any other case, but in this case they...
But it's a peculiarity when I was looking at this and looking at the rules and then looking at the application that was made by P in this case, that although everybody knew what the case was about, at no stage was it, as it were, pleaded in the way that my lady has been discussing with you. It didn't lead to any difficulties, but the form doesn't require you to specify exactly what declaration you are seeking, as it happens.
No, my lord, although actually, if we could just have a look at it briefly.
Well, before we go to the form, sorry, can I just go back to the statute and follow up the question I was asking earlier? As I understand it, it's common ground that legal parenthood is a question of legal status. Yes?
Yes.
If that's so, how does section 58 subsection 1 apply at all? Because legal status is a question to be determined by the court applying the law. It's not a question of truth of a proposition.
Well, my lord, what the truth of it goes to, my submission and understanding of it is the underlying facts that justify the legal status being in existence. So in most cases numerically, the question is genetics. The dispute in normal cases, in inverted commas, is which of these people is the genetic progenitor of the child in question. That's not our question, but that's usually the question. And so the factual elements that need to be proved in those cases are simply...
That's not how I'm reading 58.1 at the moment. 58.1, to my mind, subject to your submissions, is there for a different purpose, which is that once the court has made its mind up about who is the legal parent, it has to say so, unless there is a public policy reason why it shouldn't do so. In other words, it's to show that the court does not have a discretion, having decided who the parent is, as to whether to declare it or not. Because with declarations, normally, the court has a very wide degree of latitude as to whether it's appropriate to make a declaration or not. That this is a scheme which is quite tightly put together so that, for example, you can't make declarations that are off-piste, and that when you've reached a conclusion as to legal parentage, then you have to make the declaration. To my mind, 58.1 is there to say what the consequences of the court reaching its conclusion about legal parentage. To my mind, it has nothing to do with facts. The truth of the proposition is that A or B is or is not legal parent.
My lord,
that's how the two sections link up.
I think I respectfully don't
You don't
accept
agree with
that, my lord. I think the final clause of 58.1 absolutely is performing the function of requiring the court to make the declaration and not giving it a discretion whether to do so. But my submission, the reading of the first clause within that paragraph, that the truth of the proposition to be declared is proved to the satisfaction of the court, is going to the underlying factual...
Yes, but what are they... I mean, the court is satisfied that the mother got into bed with A but not with B. That's not the sort of thing that the proposition relates to. It's to do with the legal consequence of its findings.
My Lord, I think yes, but I think it's a bit the same as when one looks at the threshold conditions for care proceedings, and we've put the analogy in the skeleton argument in relation to this, and we can go to it if we need to, but in relation to threshold, the question of whether the threshold is met is a legal assessment based on findings of fact that the court has made, and we say it's effectively the same here. My Lord puts the point of whether you were in bed with A or B, but that is basically what the genetic test determines in a conventional dispute of this kind. And so that factual basis, we say that is the part which is proved to the satisfaction of
Right,
the
well,
court.
we'll have to make our mind up about what 58.1 is directed towards. Your submission on that is that it's directed towards the underlying factual findings.
My Lord, yes, that the court needs to have made those findings such as to justify the legal conclusion that is then declared as a result of it.
And so because the court cannot be satisfied as to the underlying factual finding, in this case, consequences.
The declaration should not have been made. The court may only make the declaration on being satisfied of the proof of the truth of the proposition to be declared. And we say in this case there was no sufficient evidence on the judge's findings that allowed her to say that that had been met. So the person who is seeking the declaration, we say, is the one who has to prove the underlying factual elements that justify that declaration being made.
Now, in one view, that might, in a sense, be your headline proposition for this appeal,
Yeah.
and your only proposition. And if it's good, then you succeed. But I suspect it's not your only proposition. But I'd just like to be clear where Section 58 comes in your hierarchy of argument.
Well, we say it's one of the things that points to the...
But it wouldn't be a pointer, it would be a knockout.
Yes. Yes,
I mean,
that's right.
if you're right about the interpretation of 58.1, then I'm not quite sure what the answer the other parties could bring.
No. But I don't think that if we're wrong about it, that's the end of our case either. It's our...
Well, is it just because I only want to be able to appreciate your case in the way that you put it? Is it your main argument?
My Lord, yes, effectively, that the burden of proof of this case fell on P. That in general terms, that isn't in dispute in one sense, that's accepted, there was a burden on her. But the issue isn't so much, in a sense, about whether the burden was on her, but what it was she had to prove.
Yeah.
And so what she, in fact, proved was the genetics, which wasn't in dispute, and the sexual intercourse.
Yes.
But what she didn't prove
Was the
was
result.
conception. And that's the thing which is actually determines whether the HFEA is involved or not involved, is the method of conception. And so the person seeking the declaration, we say, on purely conventional grounds, the person who's seeking a declaration had to prove the things that were necessary to persuade the court that what she wanted to have declared as the truth was the truth.
Would you accept that one can prove that something is unknown?
I think that's probably the consequence of the judge's findings here. We can never know what the answer to this question is.
Yes, but my question is a general one. Would you accept that you can prove that something is unknown?
I'm not sure I want to accept it as a general proposition, my lord, because I
All right.
think...
Well, let's. That's a very fair objection. but coming on to the facts of the case, I assume you would accept that you can prove that the mechanism of conception is unknown.
where I'm struggling to answer, my lord, is that I'm not sure that it being unknown per se is a fact.
Well, why not?
What it is, in my submission, is the inability to know the answer to a factual question.
It's unknowable, is the point.
It's in this case, it is unknowable. One of these two things led to the conception of X.
Well, the judge didn't put it in this way, but I wonder whether there's any difference between saying that it's unknowable or that it's equally likely to have been caused by one method of conception as the other.
Yeah.
Does anything turn on that, or might one express it in another way, which is a bit less philosophical?
I think on the fact, it certainly doesn't make any difference.
It doesn't, in these facts,
in these facts, it doesn't make any difference.
I mean, the judge, as it happens, I mean, I was expecting, reading the judgment, that she would probably say at some point that I don't know, and it's equally likely to be one or the other. She doesn't actually use those words, but that's the effect of what she's found.
Yes.
Well, if one looks at it in statistical terms, why is it not a fact that something is, that there is a 50% probability of one explanation and a 50% probability of the other explanation? Why is that not a statistical fact?
It may be a statistical fact. I'm not trying to be difficult about it, but it may be a statistical fact, but it is not a finding of fact that the court, I think, is in a position to make on the evidence, because we don't know. We don't know whether it's 50-50. We know that we don't know. We're a bit in the territory.
Well, if there was a balance of probabilities, the judge would have so found.
Yes.
But her finding was that, that there was no balance of probabilities, so it's a 50-50.
I think that's a fair conclusion.
There may be other situations which we won't take a lot of time in imagining up, where something could be said to be unknown, but it wasn't 50. What's out there in space, that you don't know what's there, and it won't necessarily be 50-50. It could be 50,000 different things, and one has no idea. On the particular facts of this case, unknown and 50-50 rather coincide.
They coincide.
And I think that the way my lord puts it, namely, that it is equivalent to 50-50 probability, is what led the judge to her dilemma.
Yes.
And certainly a finding that something is equally likely is well known to the court, and there are many cases in which the burden of proof does come into effect because you just can't tell.
What it certainly, forgive me.
I mean, uncertain perpetrator cases, for example, where it could be either parent.
Yeah.
The court may easily find that it's just as likely to be the one as the other.
But it doesn't necessarily follow that they're 50-50, because there could be three unknown perpetrators.
Yes, I'm talking about the two.
Yes, my lord. I was just going back to my lord Justice Arnold's question of whether it's necessarily therefore 50-50. But in this case, yes.
No, I mean, as my lord points out, my original question was too broad because there were other possibilities. But on this case, it is strictly 50-50.
What it most certainly isn't is the discharge of a burden of proof, because it hasn't surpassed the more likely than not. So it has shown that to take my lord's point, it's equally likely as not. But that's
indeed,
not.
and that's one way of looking at this case, is what is the legal consequence of the fact that neither side can discharge the burden of proof?
Yes. And it comes back, I think, to that fundamental starting point question of how do we know which of the two schemes is the starting point, and which is to be applied, if not disapplied. And our position on that obviously clearly is the HFEA is engaged on this case. Everybody thought it was engaged, and the person who was seeking to apply to have it disengaged was P. And for her to then be able to say...
You started this by saying the HFE is engaged.
Our position is that it is engaged.
Well, you're rather having to say, aren't you? One has to assume that it was engaged.
I think that's right.
I mean, saying it is engaged just begs the question. One has to approach the matter on the basis that it was engaged, but That's really that's the question.
That's the question. I mean, we accept that, and obviously we accept that there are perfectly well scenarios very close to the factual scenario of this case, where it easily becomes clear that it is disengaged.
Well, one could have a situation, for example, where there had been numerous events of sexual intercourse, and maybe one attempt at AI, where in that circumstance the court might quite readily find that it was much more likely that the conception was a result of sex than of AI.
And Mrs Justice Knowles, as my Lord Justice Arnold says, could have made that finding if that's what she thought the facts
But
showed.
those weren't the facts.
But those weren't the facts. But one can compare your Lordship's first instance decision in M and F and H, which we have in the bundle, so Authorities 172 if one wants to look at it. But there, your Lordship heard evidence and made a factual finding that conception was a result of sexual intercourse. And therefore, the HFEA scheme could not be applicable. And the answer was...
Well, that wasn't to do with statistics, as I remember. It was to do with who was telling the truth.
Quite. And so quite simply...
Whether they'd had sex or not.
Whether they had had sex or not, in that case. But so one can see that in a superficially similar set of facts, there may be quite different circumstances which allow the judge to make a relevant finding. And in that case, what happened was the person seeking to have the finding made that this man was in fact the father because conception came out as a result of sexual intercourse, led evidence that persuaded the court that that factual finding could be made. Whereas on our case, the evidence that's led doesn't lead to the conclusion that P needed to get to. The evidence that led leads to the possibility that conception was bisexual intercourse, but not the probability that it was bisexual.
The architecture of your submissions, as I'm seeing them at the moment, is that this heavily depends upon Section 58. That you say that because of the terms of Section 58, read with Section 55A, the court had no business to be making declarations at all.
Yes.
It should not have made a declaration, and then we survey what's left, and there's the birth certificate.
Yes.
And everything that people had thought that represented.
Yes.
And that the doubt that is that remains in the air as to the 50-50 conception just has to be lived with, and you fall back on the birth certificate.
Yes. And X continues to live her life as she has always thought she was living her life, that P and Q are her parents, and F is an important person in the background.
So in that way of putting it, are we missing out on any essential part of the architecture of your submission? Or is that really how it works? That it's not to do with approaching it through the HFEA. It's to do with approaching it through the FLA and saying that where the court can't be satisfied that the applicant for a declaration has made out their case,
Yes.
then that's something that declaration should not intervene, should not be made, and you're then left with the pre-existing situation, which happens to be a birth certificate in your favour.
Yes, although coming back to our discussion of the birth certificate earlier, I don't think the birth certificate is what turns it. It's a document that provides evidence of what they
what is it
how
that then establishes your client's parentage?
Well, I think we go back to the discussion earlier, where I'm not sure I persuaded your lordship very successfully on that relevance of that context, but it goes back to this is a married couple who did a thing which is specifically provided for them to do.
Well, you fall back on everybody thought,
Yeah,
basically.
everybody thought, but most particularly they thought, they as the people who were conceiving and having this child together.
Well, I may have misunderstood, but I was rather getting the impression that the way you were putting the case was to say that that's actually the starting point. So you start with what everybody thought as evidenced by the birth certificate. And then you say, that's the starting point. Then there's an application under section 55A and 58 of the Family Law Act. And so that's why the burden of proof is on the applicant. to displace what was previously thought to be the case.
My lord, I think it exactly so, but I think it also applies equally whether one specifically starts out that way or whether one simply says in a more conventional way there was a position that everybody understood to
So
be
you fall back on it.
Yeah.
That having fended off the declaration for legal reasons that you explained to us on these particular facts, you then fall back on what everybody thought. So whether you call it a starting point or the fallback position, we understand.
Either way, the burden on the person seeking the declaration was to disprove that fundamental starting point of what everybody thought was in place, and she didn't. She showed there was the possibility, not the probability.
That's helpful.
I was going to take your lordships and your ladyship to the application form that was issued in this case.
Yes, can I just take stock? You've been much interrupted, so this is not my way of it. How are you getting on with your submission?
I think actually quite well. The court's interventions are extremely helpful in allowing us to get through in ways that are...
I mean, will you, for example, be able to complete them by about 12:30?
I think so, yes.
Yes. I mean, don't watch the clock, just to make sure that we're not going to be squeezing other parties.
No, I'll aim to be finished by 12:30.
Yes, so we're looking at the form, are we?
We are, my lord, and in the main bundle, it's at the relevant part I'm looking at is at page 101. This is box 3, why are you making this application? And if one looks at the final paragraph in that box, I won't obviously read the names out, but although artificial insemination was also attempted, the applicant believes that X was conceived through sexual intercourse, and as such, the provisions of Section 42 of the Human Fertilisation and Embryology Act do not apply. Well, quite so. The word that's important here is conceived. This is what she had to prove, and she knew this is what she had to prove because she wrote it on her own application form. And so we say that's of some note that when this case began, even the applicant's case in the court below was that she needed to prove conception.
Well, it's a good jury point that people's parentage isn't going to be decided on the basis of what somebody thought.
Well, my lord, no, but it's obviously how the case was understood, because if one looks at the Guardian's position statement in the court below that we have in the supplementary bundle, I don't think we need to turn to it. It's just a single sentence that I pulled out from it, and what the Guardian's team said in the position statement was that the fact that needs to be determined as a consequence of P's application is that X was conceived through sexual intercourse and not conceived through artificial insemination. So this is very much the heart of our position, and I raise those points to emphasise that was very much live before the judge below. I'll just take a moment to see where we are. And the difference between that approach that we say is what the judge should have adopted and what she actually adopted is of course, the position now sought by the respondents in this case, and in my learned friend Mr. Turner's document at his paragraph 28, which in the bundle, forgive me, is at page 47. Mr. Turner's paragraph 28 begins, in the present case, P has satisfied the burden of proof, the burden of proving that F is the second legal parent of the subject child because she has satisfied the burden of proving he is the biological father. But that begs the question of whether the test is biology or not. So it comes back to, was that enough for what she had to prove? And we simply say that
yes, so in the helpful list of what P had to prove, you all agreed that she had to prove that F was the genetic parent, that she had to establish that intercourse had taken place to the extent that one couldn't tell. And you say she also had to establish that that intercourse had led to conception. She disagrees.
On the balance of probabilities.
So
Yes.
the third question is the third matter.
Yes.
Is what lies between you.
Yes. Can I take us to a paragraph of the judgment
Yeah.
below, page 51 of the bundle? Sorry, I beg your pardon. Paragraph 51, page 82.
Yes.
This is the final paragraph under the heading analysis in the judge's judgment. And it's obviously quite a long paragraph. But I'd like to pick it up, if I may, about 2/3 of the way down, where the judge deals with, one can see on the right-hand side, she refers to section 42, so just above there. Where two women are married or in a civil partnership and a child was conceived and born as a result of sexual intercourse, the legal parenthood of the non-gestational parent conferred by section 42 would remain intact if there was no challenge by either the sperm donor or the gestational mother. Yes, we don't disagree with that. She then says, it's a status more apparent than real and built on shaky foundations. And then, unsurprisingly, it is capable of being displaced if the sperm donor and the gestational mother come forward at a later date to attest to natural intercourse or a lack of consent at the time the child was conceived. Now, I'm not trying to start this as if we were doing statutory construction, but the difficulty we have with this is that it gives some insight into the judge's thinking, and it shows the bar being set too low for what she's asking to be proved. We say it can't be enough to show that natural intercourse took place at the time the child was conceived. It has to be shown that conception was as a result of that sexual intercourse, and not. Obviously, one might have a case where there was no AI going on at the same time, in which case proving that sexual intercourse did take place would suffice, because there was no other mechanism in play. But here, where we've got both mechanisms in place, it can't be right that simply the fact of sexual intercourse in itself displaces the HFEA scheme. So there's two different ways of putting it, the way the judge puts it and the way that I would put it, as in my alternative being that it is the conception, evidence of conception caused by sexual intercourse.
But are you submitting that the judge actually applied a test, namely that if it might have been the result of sexual intercourse,
Yeah.
then that is enough for the declaration to be made?
My lord, yes, that is exactly what
But
we
because
say.
I appreciate that the reading of this, and there's a later passage as well in
Yes,
64,
65.
65,
exactly.
taken in isolation could be led to read that. But that wasn't what she found. That her finding was, as we've established, that it was either unknowable or equally likely. The judge was not finding that there's a possibility. If she had been reaching that finding, then there'd be an appeal on the basis that that she got her facts wrong.
Yes.
So I'm not sure where this leads. I appreciate that you will highlight words where she suggests that she's applying just a might have happened approach, but that's not what she's actually doing, is she?
Well, I think with respect, my lord, she is doing that, because not in terms of the factual findings, but in terms of where it takes her in the legal analysis. She thinks in her analysis that having made the factual finding that it could have been one or the other, that has displaced the HFEA scheme, and that is a legal conclusion that she reaches. And we see, my lord's pointed to paragraph 64, and it's where I was taking us next as well, that she differentiates in her language two different things. So in paragraph 64, it's in the second page of that paragraph. The presumption that she set out can be rebutted by evidence which shows, and she posits then two possibilities. First, that consent has not been given, or, from the judge's analysis, that assisted reproduction may not have occurred. This is the case. In this case, the burden of proof lay on P to produce that evidence. And so she's limited the evidence that she's asking P to produce to being evidence that it may not have occurred. The artificial insemination as the means of conception may not have occurred. And we say that shows a misunderstanding of what it was that was being asked of him. And if we could continue with 64, the judge comes to the findings that she's made that my Lord Justice Peter Jackson refers to. In this case, I have found, on the balance of probabilities, that Q did not consent to anything other than assisted reproduction. Fine. I don't actually think the consent issue is relevant, but fine. But the method of X's conception was unclear because P and F had natural intercourse during the relevant conception window. So those are her findings. And then the conclusion is the following sentence. In those circumstances, the presumption of Q's legal parenthood is rebutted and the common law position applies. And it's that leap from the limited finding that she has made that there's the possibility, not proven, that conception was not by way of artificial insemination, to the conclusion at the end of that paragraph that therefore Q's legal parenthood is rebutted and the common law applies.
The question is whether the judge was right to describe there as being a presumption of Q's legal parenthood.
Yes, I'm not sure the word presumption is...
It's not correct on any analysis, is it?
No. But if we substituted the word presumption for starting point, or fallback position, which is a phrase my Lord used earlier as well, I don't think it changes my point, which is that she has leapt from the possibility to the conclusion when the possibility isn't a finding of fact and isn't shown on the balance of probability.
Well, I could see a lot of force in these arguments if the factual situation was that the apparent likelihood on the facts was, for example, there had been 7 occasions of AI and just 1 instance of sex. And the judge was saying, well, because there's been 1 occasion of sex, then that's enough to make a declaration. But these observations, whether they're correct in law or not, have surely got to be seen in the context of what actually happened in this case, which was, I think the evidence was 3 occasions of each.
Yes, but during the relevant conception window for X's actual conception, as understood on the evidence, once of each.
Once each, yes.
But either way, it comes to the same thing, equal occurrences.
But I do take the point that you're making about some of the analysis of this paragraph and of paragraph 51.
Can I just take a moment to check my note, because I think we may have, in fact, covered most of what I needed to cover.
Take your time.
May I just turn my back from it? Thank you. My lord, my lady, we obviously also rely on various points in the skeleton argument that we
Yes.
haven't gone through in detail, but all of that remains self-evidently. But unless I can assist the court further,
No, Professor, thank you very much indeed. That's been very helpful.
thank you.
Yes, Mr. Turner.
My lords, my lady, I trust that the members of the court have had the opportunity, indeed taken the opportunity to read
have.
our skeleton argument. Can I just highlight one typo in our skeleton argument? It's in paragraph 9, that's page 52 of the core bundle, 42 of the core bundle. In the 6th line, the reference in brackets should be to P,
Yes.
not to Q. So it's this alphabet soup problem
Yes.
in referring to the parties by letters. And obviously I'll refer to the parties by the same letters as everyone else has.
Please.
My client being P, the birth, the gestational mother. Before I go any further, when introducing the advocates, no mention was made, and it should be made, of the fact that Miss Baisley and Mr. Eaton are acting pro bono on behalf of the second respondent, as the representatives of the second respondent have throughout, although Miss Baisley is new to the case.
Thank you very much.
Applicants. And I suppose in the same scheme I should also mention that my two juniors, albeit we're legally aided, are sharing the junior legal aid fee between them. So not exactly pro bono, but nevertheless.
Well, you'll take them for a good lunch, Mr. Turner. That doesn't have to appear in the order, but...
Unfortunately, that doesn't affect the interesting philosophical arguments, such as what's the meaning of truth in
Yes.
section 58. And I'll come back to that, because funny enough, section 58, which as my Lord Justice Arnold pointed out, was created before any of the human fertilization and embryology legislation came into being, even before the 1987 Act, has never been amended to take any specific account of situations that might be thrown up. And indeed, although it's not in the authorities bundle before this court, there was a case before Mrs Justice Knowles, a decision of the Court of Appeal called Ray S, in which Lady Justice Black had been giving the judgment of the court, and it was all to do with the exceptional situations when public policy or welfare of the child means that a declaration won't be made. And in looking at section 58(1) and section 55, her ladyship said that those sections in the 19 where are we?
Well, I think 86 Act, yes.
1986 Act were very confusing and difficult to understand.
It's difficult to see why one comes in 55A and the other comes in 58.
Yes.
And
And the application of them, her ladyship said that they're very difficult provisions to understand, and the interaction between them in any of
I think
them.
that's Ries back in 2013 or something of that sort.
Obviously, we rely on the submissions made in our skeleton argument, and we rely also and adopt all the submissions made in Miss Baisley and Mr. Eaton's skeleton arguments. There is a hearing this afternoon. Professor George isn't involved in that hearing, so he has no reason to know. But effectively, subject to the finding of this court, there's very little actually substantively in dispute, it would appear, between the parties.
But it doesn't just diminish the importance of the
No,
issue with
of
which
course
we're
it
concerned
doesn't,
at
but
all.
your lordship
I mean,
asked...
If there is a measure of common ground between the parties, that's very good to hear.
But in human terms, and Professor George did mention human terms, it's certainly not a situation where Q is going to be shut out from the child's life, or there's any suggestion that she should have any.
No, well, that if it's the case is good to hear, but it wouldn't make any difference to us if she was going to be shut out. We have to decide it as a point of law.
Yes. Can I make a few general points first of all, and then come back and try to develop those general points within the context of a rather more structured progression of argument? And I'm going to deal with the topics such as section 58, such as the rather confusing paragraph 64 in the judgment below, the question also, which Professor George didn't mention, and which I submit explains what he suggested as certain passages in the judgment below, where the judge, he said, or argued, was imposing a very low standard, merely that there's evidence of is sufficient to prove. That, on proper analysis, isn't what the judge was doing. The judge was adopting the arguments that were put before her below about the difference between an evidential burden, which only requires credible evidence, and a legal burden, which requires a balance of probabilities. And I shall be addressing the question of when an evidential burden arises in this case, and shifts the burden, as it were, onto Q to prove that which she asserts to displace what I say is the starting and indeed the finishing point in this case, which is the common law, not presumption, wrongly called in places a presumption, but it's a common law principle or rule. And that takes me to the point that it is not a question we submit of proving the unprovable, or of trying to prove the unprovable, which was a phrase that was used in argument earlier this morning, but of looking at the consequences of something being unprovable one way or the other. And in fact, the consequences are, we would submit, as Mrs Justice Tice explained in the case of X and Z, and we've got the case in the bundle, but I've quoted in our skeleton argument on internal page 10, bundle page 50 in the core bundle. I've quoted the relevant passages of Mrs Justice Tice's judgment. And she says at paragraph 33, the children's conception occurred as a consequence of IVF treatment in the UK at an HFEA licensed clinic, the common law position remains unless it is displaced by the statutory framework set out in HFEA 2008. And that word displaced is important, and remains, obviously, is important. And of course, that all engages with the question of the burden of proof, and who has to prove what, who is asserting what. We are asserting that the common law produces a particular result, because that's the starting point. If anyone seeks to displace that starting point of natural biological parentage, if they seek to displace it by purported engagement of what I'd seek to describe as a statutory construct or statutory fiction, I don't mean to denigrate the status of parenthood acquired in that way, but the reality is it is a statutory construct, then one has to bring the case strictly within the statute and satisfy the conditions of the statute. And indeed,
so
lots of the authorities...
You embrace and rely upon the description of Section 35 as being a gateway?
34.
34, yes.
As being a gateway, absolutely. Yes. And you have to satisfy the conditions in Section 34 for Section 42 to be engaged at all. Although Section 42 itself makes it clear that it only applies, although it applies to a same-sex married female couple or civil partnership, same-sex female civil partnership, it only applies where the conception has resulted from artificial insemination. One can get that both from Section 34, the gateway, and from Section 42 itself.
Could I, as we just develop this, ask you the same question as asked Professor George, which is, what logically is our route into trying to find the answer to this? I'm beginning to think that it's through the 1986 Act, and then to the 2008 Act. in a sense, because we're concerned here with an order which contained declarations, and that order was made under the court's power, tightly drawn under the 1986 Act. And so is it not logically appropriate that, as it were, we start by considering what has happened here, and then put, because declarations have to be made in cases that don't just involve assisted reproduction or possible assisted reproduction. Anything that is said about this has got to apply generally. So I don't mean to.
No.
And in fact, it might be convenient for you to continue as you mean to continue. But is it not logically going to be necessary for us to start with where the court's power comes from, and consider what the court then was tasked to do in exercising that power, before then coming on to the specifics of the case?
Curiously enough, my lord, my notes, my speaking notes, I'm going to turn to in a moment when I've made my, as it were, random introductory points, start with section 58.
Well, take your own course, because I think it actually
So that's
starts probably
precisely
with
the way
55A, there, because
Yes.
58 is an add-on to 55A.
Yes.
But it may be that in your peroration you'll do it like this, but at some point I'd just like to know how you see the sequence of questions that need to be asked.
Yes. As I say, I was actually going to start with section 48, the logical analysis.
Right, well,
if I can just make a couple more
yes, please.
General points, first of all, so one can keep them in mind. Also,
Yes.
I'm sure I haven't forgotten them when it comes back, because they're points I've thought of while Professor George has been on his feet. But if we come back to that point about it being necessary to apply the statute strictly, which has been said in many of the authorities about the 2008 HFEA, if you're going to do the things that the HFEA does, then it must be done strictly. There's an exception for the clinic errors, which one knows has been dealt with in various ways in the authorities, such
I'm not
as...
sure I'm attracted to, I mean, probably somebody has said strictly, but isn't it just it's got to fall squarely within the terms of the Act?
Yes.
I mean, it's not a question of strict construction or anything like that. I mean, either it falls within what
Yes.
we've been for a long time calling the footprint of the Act, or it doesn't.
I was going to say the phrase that's been used in lots of the authorities, and I think it originated with your lordship,
Yes.
is it must come within the footprint.
Yeah. But I don't think strictness has got anything particularly to do with that. I just think it's you have the underlying situation, and the legislation is placed on top of it, and you have to decide whether what you've got is under the legislation or it's somewhere else.
Well, certainly when the legislation was introduced, it was very novel and might have been seen as interrupting the natural order of things or changing the natural order of things. So if one was going to do that, one had to make sure that the conditions precedent were strictly complied with. And the conditions precedent are those explained in section 34 and 42. Section 42 does create a presumption, as my lord pointed out in a case called In Re S, which is the first case in our bundle of authorities. But it doesn't create a general presumption. It's the word unless in section 42 that creates the presumption.
Well, this may or may not be important, but I just want to see whether that's correct, that section 42 creates a presumption, and can we just go to the passage?
And this is part and parcel of the confusion, I think, in paragraph 64.
Yes, it is, because I'm not sure that what the judge says about this in paragraph 64 is actually correct.
It's not.
No.
As I'll explain, one can see what she means and where she got it from, but it is, we have to concede, a little confused. But happily, in the preceding paragraph 63, she set out precisely the approach.
Well, I would understand your case to be that she could have stopped at the end of 63, and that was that.
She could have done. And all the business about consent is we agree with Professor Jordan.
Well, not just about consent, but
irrelevant
about presumptions and rebutting them and so
in
forth.
this case.
They're not actually accurate.
But what is also hidden in there, in paragraph 64, is this question about evidential burdens as opposed to legal burdens. So when her ladyship talks about something which is less than a balance of probabilities, what she's talking about there is an evidential burden, not a legal burden.
Anyhow, just to clear it up.
42.
That section 42, according to this court's judgment in Ries, at page 15 of the bundle, contains a rebuttable presumption of parentage.
Yes.
It's not to do with consent, and it's a rebuttable presumption of parentage.
It does
in circumstances where the section is engaged.
And as your lordship made clear at an earlier point in Ries, that rebuttable presumption is only itself engaged if the conditions precedent are satisfied. That is, the starting point must always be, was there a conception resulting from artificial insemination, assisted consent?
And in that case, there was no doubt that it was.
Yes. But exactly, which is why your lordship didn't need to deal with that. But it's absolutely apparent from the earlier paragraphs in your lordship's judgment in Ries that it presumes, well, presumes is a bad word to use because it proceeds on the basis that the conditions precedent are satisfied, and then one goes on to find that if they're a married couple, a same-sex female married couple, and if the conception resulted from artificial insemination, then there is a presumption of parentage unless, and that goes on to the question of consent, and you can rebut the presumption by establishing on a balance of probabilities that there wasn't consent. And that's where the confusion comes in relation to it. But consent has got nothing to do with our case at all. Can I go back briefly to what Mrs Justice Tice said in X and Z at paragraph 34? She went on to say, and she was looking at some different paragraphs of the HFEA, said sections 36 and 37 of the HFEA 2008 provide a mechanism for the acquisition of parenthood by an unmarried father whose partner undergoes fertility treatment. But they're not the only mechanism for doing so. The agreed fatherhood conditions provide a statutory modification to the common law principles, not a replacement for it. As she described it before, displacing rather than replacing. As a result, where they do not apply, the common law principle remains. On this basis, Z, by virtue of his genetic paternity, is the legal parent of the children. So that comes to mind when one is talking about something that is unprovable. If you can't prove one way or another the applicability of the 2008 Act, then the common law remains. It's not been displaced, it's not been got rid of, it's not a presumption that can be rebutted. It's a legal principle based on genetics, on nature. So we certainly disagree with what Professor George says to the effect that the starting point is the HFEA. The starting point is the common law. And I shall also mention in a little bit more detail later on, or before I do that, having seen that presumption in section 42, there is only the one presumption. If Parliament had intended a more general presumption to exist, namely a presumption of parentage or a rule of parentage whenever a child was conceived by whatever means during a marriage or civil partnership of a same-sex female couple, then Parliament would have done that. Parliament chose to have one specific presumption that one can find in effect in section 42. Before I forget, as far as birth certificates are concerned, there's one point that I'd made in our skeleton argument about circularity and about the meaning of parent. Professor George picked that up and accepted it. Well, he was wrong to accept it because it's a bad point. In fact, informants can either be a parent or there's a list of other people who can be authorised informants under the 1953 Registration of Births and Deaths Act, and they're set out in section 1, which we've got. But for our purposes, they include a person who was present at the birth. And it's accepted that Q was present at the birth in this case. So Q was an authorised informant, but of course what she was informing the registrar about was something she didn't actually know because it was a matter of law. And as the judge found, neither Q nor P were aware at the time of the significance. Indeed, Q didn't even know about the natural sexual intercourse that had taken place with F. But if she had known about it, she wouldn't have known the relevance of it. So if one's looking at the significance of a birth certificate, it may have an evidential value if it relates to information provided by someone who would have knowledge of what was being, personal knowledge of what was being provided, such as the date of birth or the fact of birth, which are what all the actual authorities relate to, the fact of birth and the date of birth, not to the question of who, as a matter of law, are the parents. And again, the 1953 Act was created before there was any question of the sort of births that result from HFEA applications. When one's looking at truth, one is looking at legal truth, which is, I suppose, a way of putting what my Lord was suggesting to Professor George in the debate that took place about that. Let me move to...
So, as I understand it, you therefore accept that section 58, subsection 1 applies. The only question is how it applies.
Yes. And I'll turn to that now then in my attempt at a structural analysis. In the unusual circumstances of this case, and it is unusual, I mean, it's not a case of wide-ranging importance because it only arises because on any view of things, F is the genetic father, whether the conception resulted from artificial insemination or whether it related from sexual intercourse. He is the father. So, notwithstanding the impossibility of establishing the means of conception of the child, whether it be artificial insemination or natural intercourse, which makes the question of burden of proof crucial in this case, there are two propositions that are unquestionably true if one is looking at the question of truth, whatever true means. First, P, my client, is the biological gestational birth mother of this child. So she is unquestionably parent one. In a situation where there are to be only two parents, there's the space for the second parent. I'm talking about parentage, legal parentage, not parental responsibility, because there can certainly be more than two people who have parental responsibility for a child. But in terms of parentage, as reflected by the birth certificate, there can only be two. So we've got that undisputable fact that he, my client, is one parent. The other undisputable fact is that F is the biological and genetic father. So there can be no dispute whatsoever as to what might be called the natural, biological, genetic parentage of the child. So if he is described as the second parent of the child, that is true in a natural as well as a legal sense. It's true in a natural sense, and I submit it's true in a legal sense because of the long-standing principle of law that a genetic biological father is a parent. And that, as Mrs Justice Tice said, and had been said before her by Mrs Justice Bracewell in the earliest of the three cases, and sandwiched between those three is my Lord Justice Peter Jackson's decision in the case of M&F, which all talk about reverting to the common law principle of parentage, where a condition of applicability of the HFEA is not established. I'll come back to who has to establish it or disprove it. Of course, it only has to be disproved if it's there as a starting point, if it's engaged as a starting point, which, as you'll appreciate, we hotly dispute. There's nothing in the 2008 Act which suggests that just because you're a married couple as a starting point of the HFAA being engaged. Now, so the inevitable legal consequence of the proposition as to the identity of the second parent, being F, is that unless that position in law of parentage is displaced, then that truth, that indisputable truth, necessitates and validates not only the declaration of parentage, that F was the second parent, unless that proposition is displaced, the other side of the coin is that Q, as a matter of legal truth, could not be the second parent. So that takes us into, is the common law position displaced? And if it's not displaced, and if one's left at the end of the day, as one is in any event here, irrespective of burdens of proof, as to the unknown and the unknowable, what is the consequence of that? Well, one goes back to the starting point, the common law position. Fallback would be a wrong way of describing it, but it's there and it's never displaced. There's never the material to displace it. It has to be displaced, not some sort of assumption.
Well, can I ask a naive question? We've seen the application that your client in fact made.
Yes.
On your submission, would it have been open to her to have applied for a declaration
Just one.
to say, no,
Sorry.
for it, to apply for a declaration that F was the biological father, and leave it at that. And if she had made that application and had been successful, which presumably she should have been successful because it's uncontested, what would have been the consequence?
The declarations that are permissible in this context are those set out in section 55A of the 1986 Act. A1, it's in the authorities bundle, electronic page 435. Subject to the following provisions of this section, any person may apply to High Court or the Family Court for a declaration as to whether or not the person named in the application is or was the parent of another person so named.
Is parent a defined term?
I say I don't think it is, but I haven't checked through.
But you see, this is partly why I asked the question. Can you apply for a declaration that someone is a biological father?
Yes. Well, this comes back, of course, I suppose, to the point my Lord made earlier, that the 1986 Act preceded the legislation, any of the legislation dealing with human fertilization and embryology. But
Section 55A was inserted in 2000.
It's been inserted, yes, but no reference to any of the HFEA legislation. Let me just look at the footnotes to check that. No, it wasn't inserted by or amended by.
Part of the point of this question is to try and get some further understanding on the statutory scheme, but also it strikes me it's not necessarily a hypothetical question, although it doesn't apply in this case, because you could imagine a same-sex couple where there has been a conception, but there is a dispute as to the source of the donated sperm. So there might be an occasion for the court to resolve who is the sperm donor, even if there's no dispute as to legal parentage. So how do you get that within the Act?
Does the court need to make a declaration of parentage at all in relation to that?
Yeah, but people want to know and to have the court's confirmation, or not least the child might have a big interest in it being definitively established who the genetic
Section
father was.
58, of course, requires the court to make a declaration unless to do so would manifestly be contrary to public policy.
All right, but let me rephrase my question. Is Section 55A subsection 1 to be interpreted as meaning a declaration as to whether or not a person named in the application is or was the, insert mentally, genetic or legal parent? Or is it confined to legal parenthood? And if it is confined to legal parenthood, why?
My Lord, subject to a search as to whether there is a definition of parentage in the Act, and I don't believe there is, I would submit that it relates to legal parentage because that was all that was known to Parliament at the time of this legislation. the legislation doesn't say anything more than that, and it perhaps hadn't been appreciated that there might be a need to say any more than that. Because parentage is a well-known principle of law that genetic, biological, those who produce the gametes that resulted in the birth were parents. That was always what parents meant, unless until we came along with statutory.
But this seems very strange, because by the year 2000, when this subsection is inserted into the Act, the concept of legal parentage differing from genetic parentage was well established.
Yes.
And so you have alternative bases for parenthood.
Sorry.
And if there's no definition of parent, why should the Section 55A not embrace both possibilities?
Because I would suggest you don't need to, because if there is compliance with the HFEA, such as sections 34 and 42, someone becomes a legal parent. That's what section 42 does. It confers parentage, legal parentage.
I think
So-
it's an interesting question that you're discussing. The understanding, which I see is referred to in the preamble to the 1986 Act, is that this is powers of the court to make declarations relating to the status of a person. Status is the most fundamental element of one's personality in a legal sense, and it relates only to a legal construct. And so I don't think it's ever been considered before that if you want to prove that you're the genetic parent, that you issue an application under Section 55A.
Yes.
That if you have some reason to show that you are a genetic parent, then you make an application for a scientific test, and that then establishes, as a matter of fact, what your genetic status is. You may be successful or not in getting such an order, but this is an act which is concerned with status.
But if you're the genetic parent,
That's not a status.
no,
It may have
no.
it may have consequences. That we can have social parents,
Yes.
psychological parents, genetic parents,
Yes.
all sorts of
Baroness
parents.
Hales said
Yes,
in
but this act is concerned with status.
yes. But if you are the producer of the genetic material, then you are, as a matter of common law, someone who has the status of parent,
Well, that's a different.
and that's leading
part of
into
the
the
argument.
relevance. So, as a matter of common law, if you were the genetic parent, you could apply for a declaration of parentage, of legal parentage there on that basis, and you would be entitled to that unless your status as a parent, based on genetics, had been displaced by some other form of parentage, one of the forms of statutory construct, obviously the adoption or parentage
Part
conferred
three
by the
is, I'm sorry to
HFEA.
talk over you, but just completing the picture. Part 3 is entitled Declarations of Status,
Yes,
and this falls within that part.
yes, indeed. And 55 and 58
Okay.
both come with it.
The ignorant person in the room now has to ask the question, is there a definition of status?
As I say, all these interesting philosophical questions.
I'm sorry, that's not a philosophical question. It's a question of statutory
Well, I
construction.
think if we go back to the Ampthill peerage, Lord Wilberforce tells us that status is not just to do with who you spend your time with and
No.
who you're.
When it can be to do with who has to pay maintenance for you.
It can have to do with all those things, but it's to do with your standing in society. It's to do with your position within society.
Yes.
And that's how it's always been understood.
I say can be to do with who pays maintenance for you. That depends on which legislation maintenance is sought. If it's Schedule 1, the Children Act, then it's parent. If it's Matrimonial Causes Act, it relates to child of the family. So, and this child was undoubtedly a child of the family in P and Q, and that's why Q has an intro into parental responsibility, irrespective of whether she's a legal parent. But going back to Lord Justice Arnold's point, I say in the scheme of the 1986 legislation, it would be unnecessary to have a declaration of whether you were the biological parent or some other form of parent or a social parent or whatever, because what's clearly required is a declaration as to legal parentage, which I submit will be either you're the provider of the genetic material and therefore under common law a parent, or that position will have been displaced by compliance with some statutory conditions.
Before we leave this, can we just look at the authorities bundle at page 280?
Page
280.
In the authorities bundle?
Yes.
That's in re R.
This is from Lord Hope in re
Yes. Lord Wilson.
Paragraph 5.
Yes.
So we're situated here in 2005, looking back to recalling a decision in 1977, so we're straddling the period of the Act that we're concerned with. And one sees the use that both Lord Hope and Lord Wilberforce used to, the sense in which they considered status. In particular, with the until period, it was to do with legitimacy.
Well, that's all about status as to legitimacy or otherwise. I mean, is that a general statement as to what constitutes status?
Well,
While the court is looking, as it were, at that authority, can I take you to page within it, electronic page 292, which is the leading speech of Lord Walker. And in paragraph 39, he refers to the decision of Lady Justice Hale, as she then was, in the Court of Appeal in that case. And she'd agreed with the submissions of a certain Mr. Jackson and said that section 28.3 is an unusual provision conferring the relationship of parent and child on people who are related neither by blood nor marriage. Now, of course, P and Q were related by marriage in this case, not related by blood. Conferring such relationships...
Sorry, I lost the paragraph. Which paragraph?
Sorry, paragraph 39, it's the quotation
Yeah.
from the Court of Appeal decision, which is adopted, as one sees later on. Conferring such relationships is a serious matter, involving as it does not only the relationship between the father and child, but also between the whole of the father's family and child. The rule should only apply to those cases which clearly fall within the footprint of the statutory language. So there again is the reference to the footprint, or the, as I've called it, the conditions precedent of the statute. And then paragraph 41, Lord Walker, with whom the committee agreed, adopted effectively what had been said there by Lady Justice Hale in the Court of Appeal. So, come back to the situation about, in the absence of displacement of the common law position, it is a truth that F was the father of the subject child in this case. What would be the consequence if P had sought simply a declaration that F is the father or parent of the child, without seeking a declaration that Q is not a parent of the child? Well, in effect, one of necessity follows the other. If F is the second parent, Q can't be. So as a matter of legal proof, absent the displacement by some statutory provision.
Okay, now, again, forgive my utter ignorance in this field, but you've twice made the point that you can only have two parents. That strikes me as a very reasonable proposition, but how do we know that? Where's the provision that says you can only have two parents?
You know, I was travelling on the bus this morning. I asked myself that very question, and I'm afraid I don't at the moment know the answer. Save that, of course, it's reflected by...
But of course, if you could have three parents...
No problem.
Then the proposition you've just argued for would not follow.
Yes.
Because what you've just argued is that recognition of F as parent necessarily excludes Q. But that only
applies
works
if legal parents.
if you're limited to two. So
Yes.
I repeat my question. What's the legal foundation for the apparently obvious proposition that you can only have two parents?
And without further research, all that I can say, unless any of my colleagues at the bar are able to assist, all that I can say is that if the form of a birth certificate, which of course is a prescribed form, reflects the law, there is only the opportunity in that to name two parents.
Right. Well, I think we need to keep an eye on where we're getting to, and also to make sure that we have your submissions in relation to the true meaning of sections 55 and 58.
Yes.
So let's keep going.
Well, section 58, I say that truth is, and again, Lord Justice Arnold mentioned this in discussion with Professor George, truth is an odd concept when one is looking at a question of law, what the law, what an application of the law results in a given situation. But what it must be taken to mean, I submit, in this case, is a legal truth. It is undoubtedly the truth that F is the father as a matter of common law, unless displaced. It must therefore be a legal truth, unless one can have more than two legal parents. It must therefore be a legal truth that Q is not a legal parent of that child. So that's the only way one can fit the wording of section 58 in. But as I say, has been said in a different context by the Court of Appeal about section 58, it's not an entirely satisfactory section.
I'm not finding this quite as difficult as...
Well,
suggesting that the truth of the proposition to be declared. I mean, what the court can declare is it can make declarations as to is the parent. That we've had a discussion about whether that is limited to status and what status means and so forth. But if one proceeds on the basis that it's who is the legal parent that one can declare under section 55, then the proposition to be declared is who is the legal parent of the child. And I'm not at the moment understanding why there would be any difficulty with them fitting together in that way.
Well, my lord, of course, I'm only too happy to adopt that.
No, but I do. I want to be put right if that's not,
No,
that's not correct.
well, I'm hardly going to try to contradict it, because it would be consistent with my argument that there is no, as it were, breach of section 58 in the declarations that were made in this case. But what if the judge had just made one declaration and said, well, Professor George, although he wasn't there at first instance. I accept your argument. It can't be proved that Q was not the mother unless it can be proved on a balance of probabilities that the conditions precedent in the HFEA weren't made out. Therefore, I won't make that declaration. Where would that leave you? It would leave you with the declaration that F was the second parent. It wouldn't say anything about Q at all. I mean, it wouldn't help Q's position. You'd be left in a sort of a vacuum or a limbo in relation to Q's.
Yes, that wasn't really the point that seems to me to arise. I mean, it's perfectly obvious that these are two sides of the same coin, and that it ought to be obvious that it doesn't matter which direction you approach it in, that whether you start with the one or the other. But in this case, what you're being asked to meet is what seems to me to be Professor George's core point, which is that you haven't proved to the satisfaction of the court, you didn't prove to the satisfaction of the court, that you were the legal parent.
Yes. Well, we had certainly proved, because it wasn't in dispute, that F was the genetic, biological, as it were, natural parent.
That's step one. You succeeded in proving that it was as likely to have been the result of natural as artificial means of conception.
Well, no, the starting point, I submit, is we had proved common law parentage. So that is, I submit, the indisputable starting point. Common law parentage is proved. F is the father. Then we turn to the question of, has that been, or can it be, or is it displaced by any statutory construct of parentage? And that's when we say that we are not seeking to argue anything about the HFEA. We're saying you could stop there.
Yeah.
It's Q who says, oh, but hold on, wait a minute. I want to put forward an argument, whether one calls it a defence or an argument or whatever. If we look at Brownlee, we can find that certain defences create a burden of proof. It was her who was relying on that argument. So if she is the one who was trying to displace the common law position that existed and to continue to exist until it was displaced, then the burden of proving that was on her, on the balance of probabilities, subject to there being a genuine issue about it. And that's where I say, if evidential burden has any relevance at all, it has a relevance there.
So at stage 2, where you established that there had been sexual intercourse,
yes, and
you then threw up the evidential issue.
So that's, sorry, my lord, that's the satisfaction of the evidential burden. Not in, there was a finding of fact by the judge that on a balance of probabilities there had been sexual intercourse. That, therefore, is credible evidence that the birth...
Right, so by establishing your genetic link, you say you achieve your common law standing status, and secondly, that if you had then just stopped and said, well, I'm not going to prove there was any sexual intercourse, it was just AI.
I don't need to.
Well, no, but having, if you said, well, there was only AI, then at that point you wouldn't have discharged any evidential burden at all, because the only way the child could have been conceived was by AI.
Right.
But you didn't do that. You went further, and you met the evidential burden of showing that there had been sex.
Yes.
And at that point, you say your task was complete.
And at that point, the ball was in your court. It's the burden shifts, as it were. The burden of proof shifts. And that evidential burden has been mischaracterized by Q's lawyers in various places as being something that they say the judge accepted that it had been proved that there hadn't been that the conception hadn't resulted from artificial insemination because of this wording she used. That wording, I submit, related not to anything other than the rather lower standard of evidential burden, the standard of credible evidence to put the matter in issue to cause the burden to exist. So he or she who asserts has the burden. It was Q who needed to assert that the conditions precedent for parentage under the HFEA was satisfied, and as we all agree, she couldn't do that any more than we could disprove them. So you're left in the situation Mrs Justice Tice spoke about. If you can't prove one way or the other, no one can prove one way or the other, particularly where the burden is on one person, then that hasn't been established, and you remain with the common law situation. And that really is in a nutshell, the way in which we put our case. So the common law position remained undisplaced, or more imprecisely, remained the fallback position. That was our case as put below, and one can point that out by looking at paragraph 41 of the judgment, where the judge summarises what I've been arguing. I've been arguing in a rather more long-winded way.
No, not at all. But I mean, we have that, and you have the
So that was my argument.
and the judge
Summarised in
accepted.
paragraph 41 of the judgment. On behalf of F, the same argument was put forward, and one can find that.
Well, shall we? I mean, I think we're going to have to give Ms. Paisley a
Well, summarise
chance.
45 and 46,
yes.
and indeed mentioned there also is the fact that if you start with some sort of presumption of parentage, once you can show that the same-sex female couple are married, then you undermine the statutory non-legitimacy, presumption of legitimacy, because Parliament has decided specifically, for whatever reason.
So as I understand it, that's another aspect on which you and
then I
Ms.
come
Paisley don't seek to sustain the judgment.
Yes. Then I come on to paragraph 49, I suppose, is the next one needs to look at.
This is about Ries.
Yes, it is.
Well, speaking for myself, you don't need to trouble us about
And
that.
what's important there is her ladyship notes, and it immediately after the quotation, in bold print, it's predicated on the child being born after assisted reproduction. So her ladyship was understood exactly what.
I think she means as a result of. I mean,
Yeah. Yes.
Otherwise, it's the well-known fallacy.
Well, I think
suppose-
she's quoting what I'd said before, so it's not her fault.
Anyway, so 49, you must bear in mind her knowledge in 49 when you look at, and then 51, half a dozen or so pages in, again she refers to my Lord, Lord Justice Peter Jackson, a decision in M&F, another one about the footprint and the common law principle, and it says, if a child is conceived and born as a result of such an informal arrangement, section 42, without challenge operates. Well, it was challenged here. There was the evidential burden. And then paragraph 63, where she clearly accepts the case put forward on behalf of P and F. Starting point, common law, unless it's displaced by the statutory framework, HFEA only governs the situation that falls in its footprint, and where this is not the case, the common law continues to apply.
And you've summed it up, Mr. Turner, and saying that's really where she gets it absolutely correct. In a nutshell, that's what this is about.
Yes, indeed.
Yeah.
And then we get to the troublesome paragraph 64, But what you have to bear in mind when reading paragraph 64 is where Her Ladyship says there was much debate and oral submission about the burden of proof. One of the arguments had been about the evidential burden, and it had been submitted on behalf of Q that, well, P was the one who was seeking the relief, therefore the burden was on Q, and reference to the Brownlee case, we were saying not so, because indeed if you look at Brownlee, you will find the burden of proof can arise from, for example, a form of defence. And there's, if you're seeking to displace something, the burden must be on you, once we've satisfied the evidential burden. And I think that's possibly what Her Ladyship had in mind when she said that she found much of what was said didn't illuminate the particular issue, and there'd been an attempt, a misconceived attempt, we submit, to rely on the HFEA as providing a presumption, and saying, well, look at section 42, there's a presumption there, and it's for us to, it's for P to rebut that presumption. That was what was being said without looking fully at res. And that's why Her Ladyship says there, section 42 of the HFEA creates a rebuttable presumption that consent exists in cases of marriage, a partnership, and on any analysis the assisted reproduction is the method of conception. But you have to bear in mind, says there, on any analysis the assisted reproduction is the method of conception. So there's only the presumption, the rebuttable
Well, I
presumption.
think I don't really want to spend any more time on this
Okay.
aspect, if you don't mind, Mr. Turner. I think we have to give the other
We
parties...
accept that there are some confusing
Some time.
words within paragraph 64 and 65.
All right.
My Lord, I think really, I mean, I would just be repeating or expanding on what I've said already if I was to say more about it. And of course, I rely upon the various authorities which are quoted, referred to in our skeleton argument, starting at well, under the subheading application of the relevant principles in the present case, paragraph 28, and then there is reference to three particular authorities in paragraph 33, and certain of the important passages we've quoted, but the authorities are there in the bundle if the court wants to look at them all, and they all talk about things such as the footprint and the
Yes.
common law. And there is also, at paragraph 34, what was said on a rather different point by Mr Justice MacDonald at paragraph 49 in MS and RS and others about the significance of non-natural, as it were, parentage and the importance of establishing it properly in that situation. Well, I think unless it would help, I don't think I probably need to say anything more about birth certificate either.
No, thank you.
Which is the other point.
No, we've got your written submission about that.
Thank you.
Good. Thank you very much indeed, Mr. Turner. Yes, Miss Paisley.
Yes, of course, sorry.
Well, my lords and my lady, the court has our skeleton argument, and likewise we respectfully adopt the written and oral submissions of Mr Turner, Ms Wiseman.
Well, we're very
and
grateful to you
Mr.
and to
Lamb.
Miss Streeton for appearing. Thank you.
Thank you very much, my lord. I hope to make a few short points, endeavouring not to repeat what's already been submitted on behalf of P. First, in relation to the submissions that were made in respect of context, we respectfully submit that context has no bearing on this appeal, which is simply a matter of legal argument. Whilst it may explain the way in which X's birth came to be registered and what everybody believed for a long time, and whilst this court may have sympathy for Q in relation to the situation in which she found herself, what happened, what the parties intended, what they believed really has no bearing on the outcome of this appeal in my respectful submission. I should just, for the benefit of our client F, say that it's not accepted that he is not considered by X to be a psychological parent. She has a relationship with him as her papa.
Well, that has nothing to do with us.
But we accept that, of course. Professor George made a submission that there is extra leeway for married couples or civil partner couples under the HFEA. And he mentioned that the difference is that the procedure may take place anywhere in the world and it may be done outside a clinic and so on. There seemed to be a submission almost that conception by means other than artificial would allow you to cross the gateway in section 42. We submit that that's obviously not the case because of the structure of the HFEA, and if it needed to be added that the heading under part 2 is parenthood in cases involving assisted reproduction. So informal, yes, but it still needs to be by artificial means, by assisted reproduction. And we submit that, or we've given a suggestion of what the judge may have meant in paragraph 64, where we accept she misspoke. And we submit that it's arguable that what she meant was that once P had established that conception may have been achieved as a result of sexual intercourse rather than assisted reproduction, such that no finding could be made on the balance of probabilities that conception was artificially assisted, it followed that Q could not establish that the relevant section 34 gateway, or indeed the gateway facts, as they're sometimes called in section 42. And as a result, the presumption of legal parentage created by section 42 didn't arise. So when she spoke of presumptions, it may be, and the court may not be prepared to go that far, but we submit that it is a reasonable interpretation of paragraph 6.
But in a sense, as I understand it, your case is that paragraph 64 is not needed.
No.
And so, rather than trying to perform surgery on it, your case, I'm not saying whether I agree with it or not, is that it can simply be put on the bench and
yes.
Not needed.
Yes, one puts the judgment together. The judge got it right. The fact that in one or two paragraphs she strayed into error doesn't matter. If one takes the judgment of the whole, it can't be challenged in my
Well, this in any case is a question of law. This doesn't
No.
depend upon
No, that's absolutely right.
an issue of how she expresses it.
Yes.
Now, do you want to say anything in particular about section 58?
Yes, it has to be read with section 55A. There are no helpful definitions. It's clearly a question of status, but it's arguable in our submission that section 55A, which talks about whether or not a person named in the application is or was the parent of another person so named, we would submit that that is a factual question as well as a legal question. And if that test is passed, section 58 means that the declaration must be made.
What do you mean by saying it's a factual question as well as a legal question?
Well, is the person the parent? We submit implies the mother or father within the meaning of the law, which imports the common law test.
Yes, but the ultimate question, as I have always understood it for the court, under that section, is who's the legal parent.
Yes.
But clearly, factual findings are going to be needed in order to
Yes.
to understand
Yes.
and reach a conclusion about that question. But where we're talking about the parent, my lord has unearthed, unless you can tell us that that parents are defined elsewhere in this
No,
which I don't think they are,
no, afraid not.
then it can only be one sort of parent
Yes,
that is being considered, and it's the person who has the status of parent,
yes.
not the person who's been acting as a parent or the person who's thought that they're a parent, or various other sorts of parent.
The person who at common law is the parent is entitled to the legal status of parent unless something displaces that. So we're entirely in line with P in relation to that. That once there was a challenge to whether Q could bring herself within the Section 34 gateway, the onus then shifted to her to establish that that gateway was crossed. So in our submission, one starts with Section 58. Is there anything that displaces that? The basis on which everyone had proceeded was challenged, and therefore there was a burden of proof on her to establish that she could bring herself within the footprint of the HFEA sections that she relied upon. And so in our submission, she wasn't able to do that because of the judge's finding. Equal possibility either way. And therefore the common law position prevailed. And therefore both declarations were rightly made. First, that F was the father, and second, that Q was not a legal parent, because there was no other basis on which she could be a legal parent. Simple as that.
And do you have any answers to the question of why it is that you can only have two parents?
I'm afraid not, and I'm afraid it's one of those well-known legal facts, and I have just now, my lord, in response to your inquiry, looked to see whether I can identify a statutory provision which says that. It's in several of the cases, as it said en passant. Of course, one can only have two legal parents, but I'm afraid I haven't.
Well, maybe the answer is that it's common law, and there's
Yes.
nothing in statute to displace it.
Yes. I think that must be right, with respect, my lord. Maloney Jr. has passed to me section 45, which is at page 420. It's a different scenario, but it provides that where a woman is being treated by virtue of sections 42 or 43 as the parent of a child, no man is to be treated as the father of the child, which fits with what I respectfully agree must be the common law position, that you can't have more than two legal parents, and it makes sense in that context. Mr. Landman provided that, Mylan Jr. very, very fairly points out. And that provides support for that proposition that one can only have two legal parents. So in our submission, it's a fairly simple set of steps. The common law, F undoubtedly is the legal parent, the second legal parent. There's no issue that P is the first legal parent. And the HFEA provisions which could have made Q the legal parent are not applicable because she doesn't get through the gateway.
So I think you were the author of the steps that had to be
Yes,
approved by various people.
yes,
And you started out, everybody's agreed that step one is that genetically
yes,
your client is the father. And then in step two, it's been expressed in different ways
yes.
by different parties. How do you express any step two that you have to? I mean, let's suppose you were seeking the declaration. I realise you weren't, but
Yes.
what did P in this case have to do under step two?
So she would have to challenge the proposition that Q is the legal parent by reason of the presumption in the HFEA.
So put forward evidence that puts it in
Yes,
issue.
that puts it in issue. And she did that by putting forward evidence of the sexual relationship within the conception window, sexual intercourse within the...
Would you accept that simply raising the issue wouldn't be enough? What she needed to do and did do was to establish that, at minimum from her perspective,
Yes.
it was a 50-50 probability. Because if she'd only established that it was, let us say, picking a random figure, a 25% probability that it was natural conception, that wouldn't suffice, because then on the balance of probabilities, it would have been AI, and that would have brought the matter within the Act.
In our submission, it's slightly different because P raises a challenge to the presumption in the HFEA applying by saying, well, we had sexual intercourse within the window. She has to bring evidence of that, and then the court has to determine which method of conception is the more likely to have resulted in this child. Once the court determined that science didn't assist and therefore the court couldn't say one way or the other, then the gateway couldn't be crossed. Had the judge concluded that it's more likely that it was artificial or assisted reproduction, then Q would have been entitled by reason of the presumption and would have been the second legal parent. So it's a slightly longer process than in our submission. All P had to do was raise a challenge, provide evidence supporting that challenge, and in the end, as I understand it below, it was accepted. It wasn't.
But at that stage, having raised the challenge to the method of conception, following that, then P had to fight off the counterclaim. Yes. Which is this was AI.
Yes. So it
in a sense it comes to the same.
Yes.
Comes to the same thing.
Yes.
And it's probably not necessary for us to identify on the facts of this case exactly what the onus was on P or on your client. They had to do more than simply show that he was the genetic parent, because if there wasn't some alternative to AI, then that was the end of it.
Yes, they had to show that he could have been the genetic parent by reason of sexual intercourse, and then that amounts to the challenge, and then that was a fact for the court to determine, both in terms of whether sexual intercourse had taken place within the conception window, and second, whether it could be established that that was more likely to have resulted in the child than the artificial means. And our submission is that unless it was established on a balance of probabilities that artificial reproduction resulted in this child, the Section 34 gateway wasn't crossed and the presumption in Section 42 didn't apply. So to that extent, we submit that once the challenge was raised, evidence was provided, which, as I understand it, wasn't significantly disputed, although that may not matter for this purpose. There was an onus on Q to demonstrate on the balance of probabilities that it was an assisted reproduction.
Yes.
And the equal probability meant that she couldn't do that, and there was no other basis for her being the legal parent.
Well, is that
I think that really is it. May I just turn my back? Yes. Thank you very much.
No, thank you both very much. Yes, that's George.
My Lord, just some very brief
I'm
points.
sorry, I should...
I beg your pardon. Mr. Gratian.
promise Mr. Gratian an opportunity. Mr. Gratian, is there anything you'd wish to contribute to this from a either legal point of view or simply on behalf of X?
Well,
specifically, unless the court has any questions for me in that regard.
No, unless you're volunteering anything, we'll leave you in peace.
I'm very grateful.
Thank you.
My Lord, my Lady, just some very brief points. We were taken to the 1953 Act on the Births Registration. It is worth noting, as we can see in the copy that we've got in the bundle, there are some specific amendments to that Act by the 2008 HFEA. So it can't be said that it was written in 1953 and there it is. It's been amended pursuant to the 2008 Act. And in relation to that, I'll just, if I may, defend my support for Mr. Turner's written point, contrary to him now recanting from it, because if one continues to Section 2 of the 1953 Act, it tells you a sort of running order of the entitled
Where do we find that,
applicants.
please?
My Lord, it's page 519 of the authorities.
Thank you.
So Section 1 sets out the, which is just back a page, Section 1 sets out the list of people who are qualified informants, and as Mr. Turner rightly says, it includes anyone present at the birth. But when one looks into subsection 2, Section 2, I beg your pardon, thank you, it's the duty to register is on the father and mother, and if one looks down to subsection 2, father is replaced by second female parent in the case of an HFEA case. And only in the case of the death or inability of those people, the other qualified informants. So since Q was the one who went and did the informing, we say actually she must have been there as parent and not as merely a person present at the birth. So there's that. My Lord Justice Arnold raised the question of why you can have only two parents. I think the answer is essentially a common law, but if one looks at the various provisions of the HFEA and Madeline from Ms. Bowsley with the assistance of Mr. Landman had taken one example, one can see another, Section 33 in relation to who can be a mother, the woman who gives birth, and no other woman can be the mother of the child. So I think it's a statutory reflection of that common law point. But perhaps more challenging is the answer to your Lordship's question of what the declaration is. And I'm not sure it is actually as straightforward as we might think. And there are two cases not before the court because they hadn't come to anybody's thought that they might be relevant. But there's a decision of Mr. Justice MacDonald called H&R in 2020, and a decision of Mr. Justice Cobb, which is variously reported, but I think it's mostly reported as Remis L, Declaration of Parentage. These are both cases, the MacDonald J case refused on the facts, the Cobb J case allowed on the facts, where the person in question has been adopted but wishes to record their birth parents on the birth certificate, as being an accurate reflection of their genetic lineage, even though their legal parentage has changed by virtue of the adoption. They do not wish to challenge the adoption. That is not on the cards. And so I'm not sure that the answer to Lord Justice Arnold's question can actually be as straightforward as we're only declaring legal parentage, because certainly those authorities, which of course are not binding on this court, seem to suggest there is more complexity to it as to what can be declared. And I wonder whether we might send those authorities in short order to the court, because I think they certainly, if anything turns on my Lord's point about that, what the declaration involves, I think there is authority that we haven't any of us.
Right, well, let me step back from any expression of certainty about what is going on in Section 55A in terms of declaration of parentage, and just understand, because I've had a recent occasion to look at the two authorities that you've just mentioned, and let me understand what it means for your submission in this case. I mean, rather than just to check whether we're just engaged in some sort of light legal dusting to make sure that we've got our
I think
clear.
it is legal dusting
rather than it biting on your appeal.
Yes, because the reality was the application was for a declaration of legal parentage. I mean, that is what was sought. The question of whether P could have sought the declaration that Lord Justice Arnold raises, the question of leaving Q as she was but also recognising F as the sort of biological father separately, I think might have required more thought, but it wasn't actually the question.
But as a matter of fact, with your knowledge of this legislation, what in your submission is meant by Section 55A when talking about a declaration of parentage?
Well, my lord, I had always understood it to mean legal parentage, but then I read Donald J and Cobb J's judgments and had to somewhat revise.
Those are to do with re-registration of birth, aren't they?
But the declaration is under Section 55A.
But via that gateway.
Yes. But the declaration must be fundamentally the same as in this case, because it's the same statutory mechanism that it permits the court to take
well, I'm bound to say, it seems to me that there's maybe some merit in that approach, because as the adoption example that you just illustrates, it confirms that people may want confirmation of genetic inheritance, even if it doesn't affect legal parentage.
My lord, certainly in the abstract, I certainly
there
agree.
ought to be a jurisdiction in the courts to do that.
And my lord, that's the conclusion that those authorities come to. And as I say, MacDonald J declines it on the facts, and Cobb J grants it on the facts of his case. But I raise it only because it comes to your lordship's
that's helpful.
question. Finally, if I may, we were taken to paragraph 51 of the judgment below, which is page 82. This is the page where the judge talks about, without challenge, what section 42 of the HFEA does. And obviously, it's right that there has been a challenge here. But what she seems to posit is we say, our position, which is that the HFEA is in operation until it's challenged. Nobody, if no challenge had arisen, Q would have proceeded as the parent of this child. Everybody would have thought so. Q's parents would be the grandparents, and so on. Inheritance would have flowed, and so on. And that's what the judge herself posits as happening in paragraph 51, when she says, without challenge, section 42, without challenge, operates to clothe the non-gestational parent with legal status. And we say she was right about that. Can I assist further?
Anything else?
No, thank you very much.
Well, thank you all very much indeed. We will rise to consider this, and because of the time, we're not going to hasten. We will consider whether we're able to give you a decision and let you know when we reconvene at 2 o'clock. And that, I think, based upon what you told us about the arrangements in the other court, is not going to make matters even worse for you than they already are. Appreciate it's a full day.
And of course, we can let Mrs Justice Knowles know.
Thank you very much.
All rise again.